Good morning. Will the Committee on Zoning please come to order? At this point in time, I would like to welcome Committee Vice Chair Santos Tam, Councilmember Wire, and Councilmember Tupola. I would also like to welcome Councilmember Cordero, who is participating remotely by video conference. Councilmember, are you there?
Chair, she is not logged on.
Later on, yeah? We'll address it. And for today, Councilmember Kia Aina is excused from today's meeting. This is a procedural announcement. Pursuant to Section 92-3.7 Hawaii Revised Statute, this meeting will be conducted as a remote meeting by interactive conference technology with the following procedures in effect for the meeting. Members of the public will be allowed to provide an oral testimony on all items on the agenda in the following order: in person, in the council chamber, and remotely. So there are two ways to do it: in person and remotely. In person and remote oral testimony will be allowed when each agenda item is taken up. Before testifying, each person shall state their name for the record. Each speaker will be limited to a 1-minute presentation on each item. All persons who have registered to testify in person will be called upon then first. When your name is called, please proceed to the podium, and when the timer goes off, please conclude your remarks promptly. Persons who have not registered will be given an opportunity to testify following the registered testifiers. I will then proceed to remote testimony via video conference or phone. When your name is called, please monitor your screen and activate your audio feed when prompted. For those who are joining us by telephone only, I will identify you by the last 3 digits of your phone number. When your number is called, please listen for the prompt to unmute and press *6. Persons who have not registered to testify remotely will be given an opportunity to offer testimony. To indicate your desire to speak, please use the raise hand feature in Zoom or press *9 on your telephone. Some friendly reminders and tips: video conference once more from a very quiet location if possible. If you are also watching the proceedings on Olelo, please mute your television at the time you're called to testify. When the timer on the screen reaches 0, please conclude your remarks promptly. Hawaii Revised Statute Section 92-3.7 requires that all votes at remote meetings be conducted by roll call unless unanimous. Therefore, I will first call for objections, and if there are any, I will then call for a roll call vote. For those members who are participating from outside the council chambers, in accordance with Hawaii Revised Statute Section 92-3.7, the meeting will automatically recess if we lose audio-visual contact when you and we cannot reconvene until they re-establish the contact. Therefore, please notify me if you will be leaving the meeting, even if only for a short period of time. Written testimonies, including the testifier's address, email address, and phone number, will be available to the public as described on the posted agenda. As a courtesy, please turn off all cell phones for the duration of this meeting. At this point in time, agenda item number 6, Resolution 24-255 has been canceled. That is in regards to the Waimanalo Beach Park. Moving on to agenda number 1, Resolution 24-237. This resolution confirms the appointment of Christina O'Hara to serve on the Zoning Board of Appeals of the City and County of Honolulu for a term to expire on June 30th, 2027. A public hearing on Ms. O'Hara's appointment was held at the council meeting on October 9th of 2024. So at this point in time, members of the Zoning Committee, we have here before us the appointee to the Zoning Boards of Appeal, Christina O'Hara. Christina, would you, okay, please. Please proceed. There you go.
Oh, hi there. Are there any questions for me?
Okay. Councilmember Wire, questions for Ms. O'Hara.
Mahalo, Chair, and mahalo, Ms. Ohira, for your willingness to serve the community. I was wondering if you could maybe walk us through a little bit of your background and your practice and just how you hope to use that to serve on the Zoning Board of Appeals.
Oh, yeah. So my practice is largely transactional. That means I do anything that doesn't go to court. My primary practice area is actually land use and real estate. We have a lot of, oh my gosh, sorry, so embarrassing. We have a lot of hospitality clients. So my practice area focuses largely on those sort of areas, so like development in the Waikiki district or resort districts on other islands. I also have some smaller clients that do affordable housing, LIHTC funding, so low-income housing tax credits, leasing, subleasing, and that sort of stuff. Yep.
Thank you. And then last question, Jar. Just, I know that there's quite a heavy caseload at Zoning Board of Appeals, and so just wanted to make sure that time commitment is within what you'd be able to handle and work on.
Yeah, so I did have some prior conversations with the current chair, and we talked about the workload and the time commitment, and it did sound doable. I do practice before the Liquor Commission. Those meetings are on Thursdays at 4 o'clock, so I did also talk with him about some of the scheduling things that might arise. But it sounds like I could either push myself later, like at the Liquor Commission hearings, if I know it's the same day that there is a zoning board meeting, so that I would be able to attend both. Yeah.
Thank you. Thank you, Chair.
Okay, thank you very much. Any other questions for Ms. Ohira, the appointee for the Zoning Boards of Appeal? At this point in time, there are no questions at this time, so would you like to say a few words or anything else? I hope you do enjoy the position.
Yeah, I mean, it does sound like a good position to, serve the public. I know that there's been some struggles to have a full board, which can result in, quorum and having difficulty managing the cases through. I also was talking to the chair actually about some potential ways to expedite that process and, get cases heard more efficiently, or even bump out cases that are not appropriate for the Zoning Board of Appeals to hear, because it sounds like some of those cases are, for whatever reason, making it to the board, and then they have to kind of dismiss them at that point, but that sounds like they should have been dismissed earlier. But yeah, so I'm looking forward to kind of helping with that process and listening to, all these different things and expanding and growing in that way.
Okay, thank you very much. Ms. Ohira, the chair has just one more question, and it's just a request. If you feel someday when you go through this experience as a board member, and there are the opportunities of looking at revising or amending the county ordinance, improving the zoning boards of appeal, please share it with the members of the council if there is any room for improvement.
Yeah, that'd be awesome. Thank you.
Okay, any further questions for Ms. Ohira? Okay, Councilwoman Tupola.
Thank you. Thank you, Ms. O'Hara, for being here. I had a quick question. So we get this nominee appointee forum, and one of the questions, number 10, says, do you foresee any possible conflict between your present work, financial investments, business transactions, or any other activity which would be incompatible with the proper discharge of your official duties or hinder you from effectively carrying out these duties for which you have been appointed? And you answered yes.
Yes. So because my firm does represent a number of clients before DPP, and some of those cases do go to ZBA. So I wanted to answer yes to, accurately respond to that question. I spoke to both chair and corp counsel for the ZBA, and they said in those instances, I would just recuse myself. And then that way, there'd be no impropriety.
Okay, yeah, I think maybe writing that out in here, because these are public documents that the public sees. And so I definitely think on a question like that, when someone answers yes, most of the time it's like, okay, this isn't going to work out. So maybe just writing what you just said. I think you're always welcome on these to kind of expound on your answers. And I think for public, transparency, just write all of that in here, because not everyone listens to these hearings.
Oh, Oh, good idea. Yeah, if I can I revise it and resubmit?
You can ask because it has your signature and the date that you did, but again, it's not a big deal. I feel like you've been very transparent, but I think with that explanation, putting that in here, it's not going to hurt.
Good to know. Thank you.
Okay, thank you.
At this point, the committee will decide to, adopt it or reject your nomination. And if it is approved this morning, maybe when you come before the full council, you could describe why you stated for the record, no, yes, etc. It's as far as what you just stated. Okay,
Thank you.
any further? Oh, before I continue on, there's an attractive young lady who's on the screen. And I would also like to welcome Councilwoman Cordero, who is participating remotely by video conference. Councilmember Cordero, in accordance with Section 92-3.7 Hawaii Revised Statute, please identify each person who is with you at your location.
Hi, Chair. There's no one with me.
Great. Okay, so we acknowledge Councilwoman Cordero. Any other questions for Ms. O'Hara? If not, thank you very much.
Thank you.
We'll now proceed with remote testimony. Madam Clerk, are there any remote testifiers?
Chair, there are none.
Is there anyone standing by remotely at this point?
Chair, there are none.
Okay, how about the in-person testimony? We'll now proceed with the in-person testimony. Clerk, do we have any in-person testifiers?
Yes, Chair, we have some standing by.
Okay. Where's the list? The names. Okay, Mr. Ivan Louis Kwan. Please proceed.
Although my kako, Chair Say and Vice Chair Dos Santos Sam, members of the committee, my name is Ivan Louis Kwan. I'm really pleased to offer strong support for the confirmation of Ms. O'Hara. As indicated in my written testimony, Ms. O'Hara is a law partner of mine. And Councilmember Wire, if you don't mind, I'd like to maybe add on to what Ms. O'Hara indicated about her background, just to respond to your question. Ms. O'Hara has been an attorney for 17 years. She's a partner at the law firm Starr, O'Toole, Marcus & Fisher. She is an outstanding lawyer with great insight and judgment. The lawyers, her partners, the other lawyers in the firm really have great respect for her legal skills and her abilities. Her clients are really very satisfied with the work that she does. She's very modest. The clients that she does work for are pretty substantial. Just for example, I think it's part of the record, so I'm not disclosing anything confidential, but she represents the Department of Hawaii Homelands and does a lot of very significant work for that client. And so I think it's my firm belief that if confirmed, Ms. O'Hara will be an outstanding member of the Board of Appeals.
Thank you very much, Mr. Louis Kwan. Any questions for the testifier? If not, thank you. At this time, Ms. Lindsay Orman.
Good morning, I'm Lindsay Orman. I'm a director of Starr, O'Toole, Marcus & Fisher, and I also practice with Tina O'Hara. Tina is an outstanding attorney, as Ivan said. I've worked with her for over a decade. I've seen her handle very complex real estate and land use matters for clients, buying and selling hundreds, thousands of acres of land, complex resort deals. She's very skilled as an attorney. She's very practical minded, and I think she would be a tremendous asset to the ZBA. Thank you.
Thank you very much. Any questions for Ms. Orman? Is there anyone else here in person to testify? If not, before I proceed on, may I introduce also another colleague of ours, Councilwoman Okimoto. Okay, she's here in person. So members, at this point in time, we are now in discussion. If there is no discussion, the chair would like to recommend that Resolution 24-237 be reported out for adoption. Any discussion, objections, or reservations? Hearing none, so ordered. Thank you very much, Ms. O'Hara. Hope to see you at the full council. Okay, moving on, members, we will be taking up agenda items number 2 and 3 together. Item number 2 is a resolution 24-236. This resolution amends resolution 22-260 CD1 to extend the deadline to obtain subdivision approval for the Nana'ikeola Self-Help Housing Project located at the Mauka end of Nana'ikeola Street in Waianae and identified as tax map key 8-7-008:076. Item number 3, members and the audience, is resolution 24-238. This resolution approves and authorizes the acceptance by the city of the conveyance of a 30-foot wide lot comprising a portion of government crown lands in Lualualei, Waianae, by quitclaim deed from the state of Hawaii, the Department of Land and Natural Resources. Members, we have posted to the agenda a proposed committee draft 1 version to each of the resolutions. For your information, summaries of the amendments are listed on the agenda. Both of the resolutions relate to the Nana'ikeola Self-Help Housing Project, which is a 201H project that the Council approved by Resolution 22-260. Among other things, the delay in obtaining approval of the project's preliminary subdivision map was due to challenges in transferring from the state of Hawaii, Department of Land and Natural Resources, to the city, title to the Crown Lualualei Road remnant, which will be used as the outside loop of the project's road network. Resolution 24-236 would extend the deadline to obtain the subdivision approval for the project, and Resolution 24-238 and Resolution 24-238 would approve and authorize the acceptance by the city of the Crown Lualualei Road remnant. Members, I would like to propose 2 verbal amendments to Resolution 24-238. First, the title should read as set forth in the summary as follows: approving and authorizing acceptance by the city of the conveyance of a 30-foot wide lot comprising a portion of government crown lands in Lualualei, Waianae, by quitclaim deed from the state of Hawaii, Department of Land and Natural Resources. And second, a technical non-substantive amendment in the last whereas clause. An erroneous reference to DNLR should be corrected to DLNR. Okay, so at this point in time, we have Ms. Claudia Shea, Executive Director of the Self-Help Housing Corporation of Hawaii. Oh, press the button, Claudio. There you go.
Mr. Chair and members of the Zoning Committee, did you want me to testify on 24-236 or 24-238, or both?
Both
Okay.
at the same time.
Okay.
We're taking two together.
Resolution 24-236 extends the time on the original 201H resolution for the Nana'ikeola Self-Help Housing Project. And in the Nana'ikeola Self-Help Housing Project, self-help housing will provide technical assistance to 87 very low and low-income families to build their own houses through the team self-help housing process. We've raised the $20 million for the project, and we've satisfied all the requirements on the preliminary subdivision map and received preliminary subdivision approval on September 13th. The main challenges, as you explained earlier from the resolution, were that we had to have control of the bridge to gain ingress and egress to the site, subject site. and to utilize the Crown Lululemon road remnant as the outer loop of our road network for the subdivision. So both of those are now being achieved. Thus, we're providing testimony in support of the extension of the time limit for the final subdivision approval for Resolution 24-236. The original deadline would be December of 2024. So by extending it another 2 years to December 7th, 2026, that enables us to put in the infrastructure, get all the final approvals and certifications, and get the final subdivision approval. That would be the testimony on Resolution 24-236. On Resolution 24-238, with the assistance of the Corporation Council and Department of Land Management and several other, and the Board of Land and Natural Resources, Department of Land and Natural Resources, Oahu Land Agent, and many other people, we were able to have the Board of Land and Natural Resources agree to transfer the Crown Lululemon road remnant, which is on the western boundary of our 12-acre parcel in Nanakuli, to have them transfer that to the city and county of Honolulu. Self-help housing will be using its own funds to build out the improvements on the road with no cost to the taxpayers, and will utilize that road. We'll build it out to a 44-foot road that will be congruent with all of the city and county of Honolulu's subdivision rules and regulations and traffic review regulations. And that'll be the outer loop of our road network for the 87-lot subdivision. So I testify in support of that resolution.
Thank you very much. Members, are there any questions for the testifier, Ms. Shea? Please, Councilmember Tupola.
Thank you, Chair. Thank you, Ms. Shea, for being here today. And I know that we've talked about this, but I just want some things on the record for clarity for the public. Real quick, the Crown easement, so this is for 24238, is this the remnant of road that's basically parallel to the canal? Is that the strip? Does it go from Lululemon Naval?
It's perpendicular.
Oh, it's perpendicular.
Yeah, it's on the western side of our border. It's between Green Acres and Self-Help's land, and it actually has a bridge at the end of it. Yeah. So we're using that as the outer loop of our road network, but all of that will be dedicated to city and county of Honolulu. It'll be a public road.
So where the bridge is that like on the left side of Food Giant? Is that road that kind of goes there, goes to the bridge, and then goes out to your property?
No, the other
something
bridge.
else.
It's the other bridge further down.
Oh.
Yeah.
So is there a strip of land, because someone told me that there was Crown land, but it was actually parallel adjacent to the canal. Basically, by doing this Crown lands that's perpendicular, you're good? There's no other Crown lands in that area?
No, no, yeah.
And then I guess the last question is, where is the egress and ingress? Is it going to be through Helelu, or is it going to be through Nanikeola?
Oh, no, it's going to go over the bridge. The ingress and egress is over the bridge. We're going to take all of the gravel and the dirt off of that bridge, and we're going to improve that bridge.
Oh, I see.
Yeah, that'll be the ingress and the egress.
Okay, all right. Those are my questions. But yeah, thank you so much. I know you've been very transparent with the community about all of this. I know people are actually very excited.
Yeah, we're already providing pre-purchase financial counseling to about 3,000 families on our waiting list.
Great, thank you. Thank you, Chair.
Oh, hello.
Thank you very much. Any questions, members, for Ms. Shea, the developer and applicant? If not, okay. Thank you very much, Ms. Claudia Shea. Let's move on to the Department of Planning and Permitting, Director Apuna.
Okay, there you go. Good morning, Committee Chair Say, and members of the Zoning Committee. Jordan Dilly, Staff Planner, DPP. We are in support of the extension of the 218 project.
Okay, members, any questions for the department? No question. Thank you. Keith Suzuka, Deputy Director of Department of Land Management.
Good morning, Chairman Say, committee members, Keith Suzuka, Department of Land Management, Deputy Director. As you already heard from Claudia Shea, this is a very important project, and this is an important step towards its fruition. We have up on the screen aerial shot of the property, and the road is indicated. It's on the western side of the self-help project. If anyone has any questions, I'd be happy to try to answer them, but otherwise, we would like to have the City Council authorize the acceptance of the quitclaim deed from the Department of Land and Natural Resources to the city and county. The land would then be used as a portion of the road, and it will be built out by the developer at no taxpayer cost, and then the improvements would be dedicated over to the city.
Okay, members, any discussion for Deputy Director Keith Suzuka of the Department of Land Management? Oh, there is no discussion. Thank you. At this point in time, members, let's move on. We will now proceed with the remote testimony on Resolution 24-236 and Resolution 24-238. Madam Clerk, do we have any remote testifiers?
Yes, Chair, we have one standing by.
Okay, we have Ms. Jermaine Myers. Are you there? Hi.
Aloha, Chair. Can you hear me?
Yes, we can. Please proceed.
Thank you. Aloha, Chair. My name is Jermaine Myers. I'm a Nanakuli Hawaiian homestead lessee. I humbly ask Chair and committee members to oppose Resolution 24-236 and 24-238. The parcel of land in Res 24-236 and 238 is located next to PVT landfill in Nanakuli. It's within 1/2 mile radius of PVT. State Act 79 says it's dangerous to live within a 1/2 mile radius of a landfill. City Council Chair Tommy Waters says it's dangerous and proposed a bill to exempt property tax for those residents that live on a property within 1/2 mile radius of PVT landfill. If you support Res 24-236 and 238 for the developer to execute their self-help building of 86 homes, are you encouraging families to live in a dangerous area and to receive exemption from paying property taxes? For these reasons, I humbly ask that you oppose Res 236 and 238, especially with government crown lands involved. Mahalo.
Thank you very much. Members, any questions for Ms. Young at this point? If there are no questions, thank you very much, Ms. Young. Madam Clerk, are there any further remote testifiers?
Chair, there are none.
Thank you. Are there any in-person testimony at this point in time?
Chair, there are none.
Okay. Members, we are in discussion. Okay, Councilmember Tupola, please.
Thank you so much, Chair. Yes, I'm in support of both, and I'd like a little time to explain. This particular parcel is actually next to Helelua, so it's near the Nanakuli side of the whole entire parcel. And if you're not familiar with this area, forgive me for being so specific, but if you see the old Kaiser Nanikeola or Food Giant in Nanakuli, you go down that street, it's going to be that parcel behind there, and again, what would the word be? Adjacent to Helelua. So just to be clear, there are houses closer to PVT. Actually, the old Nakatani property, there's 30 houses there that RJ Willing and Lualu'le Homes is managing over there, as well as all the houses in Mohihi, Mikilua, and all those. And so I'm not saying that there's a justification. I'm just saying that this particular property is near housing that already exists. I will say that over the years, which I've been either a representative or a council member for almost 10 years in this area, I have handled so many homeless complaints in that area, people burning other people's encampments. In fact, one incident where a homeless individual burned another homeless individual's encampment caused the whole entire Nanakuli Mountain to catch on fire. So we had to kind of clear out that area. I will say that actually Ms. Shea has been involved in a lot of clearing of homeless in that area. And again, it's because of the negligence that happens there. We want people to get into housing. We want to help them. I have walked through that area. There are a lot of people that are living along the canal that, again, now are putting things in the canal that make the stream unclean, which is the Ulehava stream. So I am in favor of this because to leave the land vacant and to continue to have this ongoing problem because there is not use of it is not advantageous for our community. But moreover, of all the housing projects that we could ever put over there, self-help housing, that's $350,000 to start off, right? You build your house. I don't know if I'm saying this wrong or right, but 2-bathroom, 4-bedroom, you get immediate equity, you learn how to build a house, you understand and live with, work with all your neighbors. You know, Ms. Shea has done a handful of these in Waianae. People I know that live in these projects that love it, they know all their neighbors, they feel safe, they know how to repair their homes, they're actually able to afford to live here in Hawaii. So for the following reasons, especially because I am personally so familiar with this area and have worked in it, I do think it's the right way to go. 87 homes that are going to be all deeply affordable for local families, and I know a lot of people from Nanakuli, Maili, from Waianae that are trying to get into this. I want us to support this. I think that even the area where the crown lands are, to be honest, I've cleaned that multiple times. I've taken at least 10 bins of trash out of there on a regular basis, trying to clean out what's on that land. So we really do want the land to heal, but it's not going to heal if we leave it vacant. It's only going to heal if we actually change the use of it and do something productive. So for those reasons, I'm in favor. Thank you, Chair.
Thank you very much. Any further discussion, members? Well, Chair, Councilwoman Tupola, thank you very much for your insights. At this point in time, the two resolutions, if you folks all recall, it's basically asking for an extension at this time for the project. That's number one. And number two, it was the land transfer from the state to the city and county of Honolulu. So any further discussion, members? If not, the chair would like to recommend that Resolution 24-236 be amended to the committee draft 1 posted on the agenda. Any discussion, objections, or reservations? Hearing none, the resolution has been amended to a committee draft 1. The chair then recommends that Resolution 24-236 committee draft 1 be reported out for adoption. Any discussion, objections, or reservations? Hearing none, so ordered. Thank you very much. Okay, moving on to, I've got to take it 2 times, excuse me. If I stand corrected, the first one was Resolution 24-236, and this one now, the motion is for Resolution 24-238. And this is the one that the chair did recommend that the resolution be amended to the CD1 posted, and the amendment was basically approving and authorizing acceptance by the city of the conveyance of the 30-foot wide lot comprising a portion of government crown lands. So I do have to read it for the general public, and I'll start off once more. We amend the resolution title to read, approving and authorizing acceptance by the city of the conveyance of a 30-foot wide lot comprising a portion of government crown lands in Lualualei, Waianae by quitclaim deed from the State of Hawaii Department of Land and Natural Resources. And all I did at the second part was that in the last whereas, which I stated for the record earlier, whereas clause, we correct an erroneous reference to DNLR to DLNR. So any discussion? No objections or reservations? Hearing none, the resolution has been amended to a committee draft 1. Then the next step for the general public and for us is that the chair then recommends that Resolution 24-238 committee draft 1 be reported out for adoption. Any discussion, objections, or reservations? Hearing none, so ordered. Okay, let's move on to agenda number 4. Agenda number 4, Resolution 24-250. This resolution grants a special management area major permit to 2HNL LLC to allow for the construction of a new single-family detached dwelling with an attached three-car garage, swimming pool, and gated entry courtyard. Installation of a new landscaping and relocation of the driveway on an approximately 25,216 square foot shoreline zoned R-7.5, which is a residential district located at 4929 Ka'ana'anaole Highway in Waianae and identified as tax map key 3-5-002, 3-5-022:015. Members, we have posted on the agenda a proposed committee draft version of the resolution. And for your information, a summary of the amendments is listed on the agenda. Also, members, I'd like to propose a verbal amendment to amend Condition A relating to development in conformity with the project as described in the Department of Planning and Permit findings and recommendations and depicted in the exhibits attached to the resolution. To add the phrase, except as modified herein at the beginning of the condition. Once more, the phrase, except as modified herein at the beginning of the condition. Joining us in the chamber is Stephen Du from KAE Design LLC, the applicant's agent who will be providing a brief description and presentation. For your information, the presentation is available online as Miscellaneous Communication 473 of 2024. Okay, Mr. Du.
Good morning, Chair. Good morning, council members. Thank you for the opportunity to be able to speak on the project today. Unfortunately, the owner is not here today, but I'm speaking on her behalf.
Please proceed.
So this project here on 4929 Kalani'anaole Highway is a single-family, or is a redevelopment of a single-family dwelling. So it's located here in Waialaiki, so it's close by Waialaiki Park. It's in the SMA zone as shown on these two figures. Looking from, I guess, looking toward Cocoa Head and looking back toward Diamond Head, these are a couple of images that are from Google Street View. The project itself, or the property itself, has three existing buildings. One of them is a two-story building and one is a raised single-family dwelling, and then the last structure is a pool house. The owner is proposing to demolish all three and create one single-family dwelling that's closest to the highway, and trying to retreat back as furthest as possible. So some specs on the house. The overall building footprint is a little bit above 9,700 square feet with an overall total floor area of just 2 feet shy of 11,000 square feet. There is an open and covered lanai that wraps around on the first and second floor, as well as a 948 square foot garage. As mentioned before, and as was shown in other pictures, it's going to be pushed back 97 feet from the certified shoreline from 2014. Right now it's uncertified, and we're working through with the LNR to get it certified. And lastly, we'll be planting the surrounding perimeter with local native plants of the microclimate. So here's an image of or overlay of what the property will look like once complete. So as seen here, we're retreating back as furthest as possible. The existing pool house that's going to be demolished is a lot closer. It's about 50 feet from the shoreline, and that will be removed. Additionally, the driveway is going to be swapped from the Diamond Head end to the Cocoa Head end, primarily because of circulation internally and to get better site visibility of the oncoming cars on Kalani'anaole. So here's a perspective image looking from Mauka to Makai. So this is where the relocated driveway is. In the foreground, you'll see where the garage is, and just into the middle of the background, you're looking at the two-story single-family dwelling. And now looking from the Makai side, you'll see the pool, which is at the front and center, and you have the two wings on both the Diamond Head and the Cocoa Head end. So one thing that we did want to address as part of the owner's concern and what we've been hearing from, I guess, retreating back as furthest as possible. So what we've been shown from SOEST is that the erosion line over the next century will be, in 2100, will be at the foot of the Mackay side of the property. Even with that, we're still retreating as furthest as possible away from the shoreline. This is a overall image that identifies the soil erosion line as well as the passive flooding and the high wave action flooding. A zoomed in picture of that shows that the high wave action is the thing that is affecting the property at the highest. So right now the house is being situated just right outside of that high wave action. In addition, the owner has elected to elevate their finished floor elevation 1.5 feet higher than what the base flood elevation that FEMA has determined. There will be no fill on the outside of the building's footprint. However, because it's being elevated a lot higher than the existing elevation, a lot of structural fill will be brought in underneath the building slab. So the process that we are going through for this is we presented at the neighborhood board in June, and we submitted the SMA application to the city a couple of weeks later. Then we had our public hearing in August, and now they submitted DPP has submitted their recommendation, and we're here at zoning. We're looking, well, one thing that the owner did want to do is, knowing that the building permit process has taken a little bit longer, she's elected to submit her building permit application, knowing that the SMA would have to go through and get approved and all the other approvals before they can start construction. So she wanted to take a risk and try to get things going in parallel. So we're anticipating permit approval by next summer, and then 1 calendar year after that to be completed with construction. So some things that we are looking at in our SMA permit. First, we did a literature review and a field investigation. Kealapono did that. They had come back with their findings of we should be doing an archaeology monitoring plan. Both the LRFI and the AMP were submitted to SHPD. They did their review, and they recommended that we complete an AIS. So we're going through that process right now. And we know that the building permit approval can't be given until SHPD gives their sign-off. Additionally, what we've done in working with the city is we actually did a kapa'akai interview. So we'll be wrapping that up by the end of this month and submitting that. We did a biology survey, so on the flora and fauna, and ACOS didn't find any listed endangered or threatened species in the area. For the building permit, we'll be doing a stormwater, residential stormwater management plan for them. Additionally, we received confirmation from all the utility purveyors, Hawaiian Electric, Telcom, Spectrum, Board of Water, and Wastewater Branch, that the utilities are available, and we'll be able to build our dwelling. And lastly, we'll be complying with all the applicable ROHs and HRSs and the land use. So some of the objectives that we're looking at, we won't be affecting any recreation or public access. So one thing that I do want to mention, the overall project area is not going to be close to or further closer than where the pool house is. So right now there's existing naupaka along the Mackay edge of the property line. There is no permanent irrigation that's trying to enhance growth of that vegetation. And the owner has been trying to cut back and maintain that, so primarily for their views, but they've been trying to cut it back and make sure that it's properly maintained. And additionally, the recreation public access to that beachfront is through Wailopi Beach Park. Because they won't be doing any development or building, that none of the recreation or public access will be affected. nor will we alter any of the beach or adjacent waters. During construction and post-construction, we'll be managing our solid and liquid waste. So the permanent status would be, we'll be using 3-bin system, and during construction, they'll be doing their construction BMP's best practices so that no erosion or sedimentation will end up in the Pacific Ocean. And we won't have any significant adverse indirect or cumulative impact on the surrounding area. And then we'll be complying with all state and city plans and policies. And lastly, we won't be affecting any significant views. So with that, any questions?
Oops, Mr. Du, thank you very much for the comprehensive presentation. Are there any questions for Mr. Du, the engineer? No? Everybody's fine with his presentation. Thank you very much. Next, let's call upon Department of Planning and Permitting. Chrissy.
Oh, sorry about that. Good morning, Councilmember Say, Chair Say, and committee members. I'm Christy Keller, the staff planner on this project for DPP, and we have no objections to the project and CD1 as proposed.
Thank you very much. Any questions, members, for Ms. Christy Keller? If not, Councilmember Cordero?
Thank you, Chair. Ms. Keller, I have a question relating to the EIS requested and the timeline for receiving it. Do you believe that it is determined to be okay to allow for the applicant to work towards the EIS and still go through this process? Or would it be pertinent to have the applicant complete the EIS before moving forward?
I believe you may be referring to an AIS, the Archaeological Inventory Survey, yes. Is that correct?
Oh yes, AIS, excuse me. I apologize for that.
In this particular project, it was submitted to the SHPD through the 6E project process early on, and it's well on its way through the process. Also in this particular project, they're not trying to, I guess, get in behind the deadline for using like the new shoreline setbacks. So they don't have that much of a deadline. So either way, because there were potentially historic properties on the site, which have pretty much been determined that they weren't because they've been altered too much over time. An AIS for this project would have been required either way. So answer your question, no, I don't feel like this is holding up this particular project.
Okay, thank you. And just for clarification, their timeline to receive the building permit wouldn't be until next summer, possibly, right?
I wouldn't want to predict exactly, but their building permit has been in for months now, so.
Okay, thank you. Thank you very much. Thank you, Chair.
Okay, thank you very much. Any further questions for Ms. Keller? If there is no further questions, thank you very much for your responses. At this point in time, members, we will now proceed with the remote testimony. Madam Clerk, are there any remote testifiers?
Chair, there are none.
Thank you. At this time, now we'll proceed with the in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
Okay, hearing none. Members, we are in discussion in regards to Resolution 24-251, the granting a special management area major permit to allow the construction of a new 2-family dwelling with an attached garage and accessory dwelling unit. I'm at the wrong one, excuse me. Okay. Okay, this is Resolution 24-250, once again, granting a special management area major permit to allow the construction of a new single-family dwelling with an attached garage and swimming pool in Wailai, Oahu. So at this time, the chair recommends that resolution be amended to the committee draft 1 listed on the agenda as further amended as we have discussed to add the phrase except as modified herein at the beginning of the condition A. Are there any discussion, objections, or reservations? Hearing none, the resolution has been amended to a committee draft 1. The chair then recommends that resolution 24-250, committee draft 1, be reported out for adoption. Any discussion, objections, or reservations? Hearing none, so ordered. Okay. Moving on to agenda number 5, resolution 24-251. This resolution grants a special management area major permit to Yangao and Jianghong Hu to allow for the construction of a new two-family detached dwelling consisting of a primary dwelling unit and an attached accessory dwelling unit on a portion of the first floor, attached two-car garage, driveway with 5 uncovered parking spaces, entry gate, fence, and the installation of a new landscaping, a sprinkler system, and connections to the existing utility service lines on an approximately 12,356 square foot shoreline lot, zone R10, in the residential district once more, located at 84-931 Farrington Highway in Makaha and identified as tax map key 8-4-004:021. Members, we have listed to the agenda a proposed committee draft 1 version of the resolution, and for your information, a summary of the amendments is listed on the agenda. Members, I would also like to propose a verbal amendment to amend the last sentence of condition F relating to landowner acknowledgements of adverse impacts related to coastal hazards to delete reference to construction permit plans. The last sentence would read, the statements enumerated in this condition must be clearly stated under the landowner acknowledgements on all project building plans. Joining us in the council chamber is Mr. Mark Howland from Whale Environmental Services, LLC, the applicant's agent who will be providing a brief presentation. For your information, the presentation is available online as miscellaneous communication 474 of 2024. Mr. Howland, please.
Morning, Chair. Morning, council members. This is the Who property in Makaha. This is a SMA project we took over from a different firm, so some of it was done initially, but we felt that it was necessary to repeat the neighborhood board meeting ourselves, which we did, and there was very many changes made as a result of that meeting. We appreciate the due diligence of Planner Keller and Councilwoman Tapula for attending the neighborhood board meeting. It made it that this became a much stronger project. This thing's in my way. So it's in compliance with the different rules and regulations. Planner Keller, Councilman Say, sent us all the acknowledgements, the SMA requirements, the different environmental notes that are also will be on the plans, but they were also in the SMA application. So we thank you for providing those conditions. These are the site photos. This is a vacant site. One of the nearby abutters is the former assistant director of FEMA. So he also contributed as a abutter with the knowledge of the site. This is the property information for the site. It's one of 2 sites. You'll see the Cook property next door come into you relatively soon. Is the plot map of where the property is located. It's near the beach condos, which are further east of the property. So you can see the relative location. Again, a summary. Now we summarize it so that when it goes to the council, many of the key factors are outlined for you to make it easier for you to draft your resolutions. So we've been trying to continually improve how we write these up so that it makes both DPP job and your job much easier. This is the land ownership is Iris Hu and her husband, and the estimated value of what the construction is going to cost. She is a Oahu resident. She should be selling her house and building this to be their new forever home, for lack of better words. This is a sample of the foundation details. Keep them as shallow as possible to make sure we're not getting into any EV depths. And cultural considerations, of course, it's been submitted to Shifty, and they've been notified, the owners, the architects, everybody, you stop if anything is detected at all. And this is also a similar condition that's been informed to the property owners and the architects and the potential builders that same considerations for endangered species, green turtles, seabirds, monk seals, etc. This is the soil type for the property. As you can see, it's beach sands on the Makai side and clays on the Maka side. This is the 3.2 sea level rise map, and then below on the right, the 0.5. Where the red balloon is basically the location also, not of just the property, but of the proposed house. I'm trying to stay as much out of it as possible. This is a shoreline survey. It's been certified on the property. This is the coastal erosion line, vegetation line on the property. Again, the work area is outside of the 3.2 area line. This is the erosion rate for the property. It's got a slight accretion, but essentially the same. So we feel the mitigations that have been put in place do help on this property. This is the FEMA map for the property. It's AE and VE, and the project is elevated for the portions in the VE zone. So that would be the overriding flood zone standard adhere to. Oh, skipped one. This is the NOAA and Tasami maps. As you can see, the NOAA map is pretty much confined to the shoreline, and as much of the Waianae is, it's in the evacuation zone for Tasamis. This is the critical habitat map, which there's no critical habitat near this site. These are the different types of acknowledgements that are being put in to make the conditions for both environmental notes regarding seabirds and different endangered species, as well as the Shifty requirements. So again, we're taking the effort to make sure that we make this as close to council resolutions as possible. So again, if there's any questions that you might have, I'd be glad to answer them. Thank you.
Okay. Any questions for Mr. Howland at this point in time? Okay. You may sit. Now we have the director, Ms. Apuna, or DPP once more.
Good morning, committee chair and members. This is Christy Keller, staff planner on behalf of Director Apuna. We have no objection to the project as revised by the committee draft 1. Available for questions.
Okay. The chair had a couple questions. The first one would be in regards to this particular project. You know, it is on Farrington Highway. It's 2 vacant properties. Is there, for maybe the council member from Waianae, is that a place where the public access occurs for residents and families to get to the beach?
No.
No? Okay. Ms. Keller, is that correct? No? That
I'm sorry, I couldn't hear your question.
The question was, does the families of the Waianae Coast utilize that vacant property to traverse from the highway to the beach?
I was, listening into the neighborhood board meeting, there were people who did express that they use that as a public access to the beach. However, they were also acknowledged that they are privately owned lots.
Right, okay. So are you comfortable, Council?
Yeah, I mean, you can access the beach through anyone's property. The fact of the matter is, should you be walking through people's property? And so, yes, there are other ways to get to the beach. But even that, if you look at these maps, that whole shoreline, if you look at the lots, the lot line is into the water because of erosion. So technically, all along that area, when you're walking on the sand, you are on people's property. And people in Makaha know that. So there are public places where you can go enjoy the beach, and I would encourage people to stay in the public places where there's lifeguards and where it's safe. Thank you.
Okay, thank you very much. Ms. Keller, the other question would be then for the Waianae Coast Neighborhood Board. Are they in opposition to this project or in support of the position?
No, they did not expect to express opposition. They requested that the area right along Farrington Highway be retained as available for public parking as it is right now, and requested that the gate into the driveway be open into the property rather than out into the public parking area, and that the applicants agreed to that.
Okay. Members, any other questions for the department? If not, may we proceed on? Madam Clerk, can we proceed on with remote testimony? Do we have any remote testifiers?
Chair, there are none.
Okay, we'll now proceed with the in-person testimony. Madam Clerk, are there any in-person testifiers?
Chair, there are none.
Okay, great. Members, at this point in time, we are in discussion.
Just brief comments, Chair.
Yes, please.
Yeah, I just wanted to thank the applicant. He did go to the neighborhood board and again, and there are quite a bit of comments, and I thank you for the adjustments that you made. Although small, I know that they felt very happy that you took that into consideration. So thank you for being transparent and for being out there with the community. I know it can get tough to present at the neighborhood board, so thank you. Thank you, Chair.
Okay, members, any other comments that you'd like to make? So at this point in time, the chair would like to recommend that resolution 24-251 no, this 251. No, I'm going to look at it from a different point of view, that the chair would like to recommend that resolution 24-251 be postponed, okay? To a time and date to be determined by the committee chair. And the chair So is there any discussion on the chair's motion to postpone?
Chair, is it for editing of the bill?
It's dealing with more with the process in regards to the SHIP-T application.
Okay, thank you.
Okay. So is there any discussion, objections, or reservations? Hearing none. It's been so ordered postponed. And the chair would like to note that the time needed to consider resolution 24-251 may exceed the current deadline for council action. So the chair therefore would further recommend that the resolution be granted another 60-day extension of time, subject to a written request from the applicant. Any discussion, objections, or reservations? Hearing none, so ordered. Okay, this one has been postponed at this point with 60-day extension. Moving on to agenda number 6. That has been canceled. Moving on to agenda number 7. Bill 58, this bill relating to the building code. Members, we do have a posted agenda to the proposed CD1 version of the bill. For your information, a summary of the amendments is listed on the agenda. Bill 58, 2024 is a housekeeping measure to make technical and non-substantive amendments to Ordinance 24-15, which adopted the 2018 Building Code. The amendments include revisions to a mandatory language correction of typographical and formatting errors, and correction of erroneous citations. Here we have the Department of Planning and Permitting, Ms. Apuna. Okay, is anyone from the department? If not, let's proceed on. Madam Clerk, do we have any remote testifiers?
Chair, there are none.
Okay, do we have any in-person testimony?
Chair, there are none.
Members, we are in discussion on the building code. At this point in time, the chair would like to recommend then that Bill 58, 2024 be postponed to a time and date to be determined by the committee chair. Any discussion, objections, or reservations? Hearing none, so ordered. Okay, this has been postponed. Moving on to agenda number 8, Bill 53. This bill relates to the special management area. Members, we have listed on an agenda addendum a proposed committee draft 1 version of the bill. For your information, a summary of the amendments is listed on the agenda addendum.
Liz is going to give a presentation for this one.
Okay, Bill 53, Department.
Good morning, Chair and committee members. I'm Elizabeth Krieger from the Department of Planning and Permitting. And I'm honored today to get the opportunity to explain what is in Bill 53 and how it would function and how it would operate if passed.
Yeah.
All right. So Bill 53 does two main things. It amends the definition of development for consistency with Hawaii Revised Statutes, Chapter 205A, as amended by Act 229 of Sessions Laws of Hawaii 2023. And then the second thing that it does is delegates the SMA major permits for 1 and 2 family dwellings to the Director of the Department of Planning and Permitting. To be clear, that's only 1 and 2 family dwellings if there are no more than 2 dwelling units on a lot. Now, Act 229, Session Laws of Hawaii 2023, added several items that are not considered development. So on this slide, I have snipped this portion of that act. So in short, you can see that the kinds of things that the legislature determined should not be considered development are things like public, pedestrian, and bicycle facilities, invasive vegetation removal, fencing for invasive species control, lighting fixtures for public facilities, and security measures, including fencing to existing public facilities. And then finally, Hawaiian traditional and customary practices, including work on local ia and traditional Hawaiian fish ponds. So essentially, the first change in the bill is just to make sure that the revised ordinances of Honolulu are consistent with the Hawaii Revised Statutes. Now, the second element, which involves delegation of SMA major permits for 1 and 2 family homes, is being proposed in part as a result of Act 16, which was Session Laws of Hawaii 2020. In 2020, on September 15th, the act came into law, and it required SMA permits for any shoreline residential development. As a result, the number of major SMA permits, increased 114% compared to the 50-month period before Act 16 was passed. So essentially, from 2016 to 2020, we had 35 SMA major permits that came to the City Council, and from September 2020 until now, we've had 75. This map shows where the SMA major and minor permits have been located around the island since 2020, since Act 16, and we're including it here just to show that it's kind of interesting that they're quite uniformly distributed around the areas that the city and county has jurisdiction. Unfortunately, the little yellow and orange dots are kind of difficult to see. Now, the reasons that the department supports Bill 53 are primarily because applicants for simply 1 or 2 dwellings on a single zoning lot will face a shorter and less expensive process. The process will still ensure full environmental review of the goals, objectives, and policies of both HRS Chapter 205A, which is the Coastal Zone Management Act, and revised ordinances of Honolulu Chapter 25, which is the Special Management Area Ordinance. This will also help conserve the city's limited resources both within the DPP and the City Council by focusing City Council's time on more intensive projects. So City Council action will still be required. Any development within the SMA with a valuation of over $500,000 requires an SMA major permit. The City Council will continue to act on all SMA major permits except for those lots with only 1 or 2 dwellings. And so the council will continue to act on all public, multifamily, commercial, industrial, and infrastructure projects. So on the next slide, I have a list of several projects that have been reviewed by the City Council recently, and this is to emphasize that these projects will continue, these types of projects will continue to be reviewed by the City Council. So you can see on here, there are beach parks, bridge replacement projects, bus transit centers, elementary schools, developments with more than 3 dwelling units, or 3 or more dwelling units, Sea Life Park, Waikiki Aquarium, Waikiki Shell, slope stabilization projects, and that kind of thing. So when we say intensive projects, that's the kind of thing that we're discussing. And then I'd also like to emphasize that public participation will still be required after Bill 53 passes, or if it passes. Applicants for SMA major permits for 1 and 2 family dwellings will still need to have their project presented to the neighborhood board or the community association for the area. The DPP will still send out notices of the application and public hearing to the Honolulu Star Advertiser, the public entities, neighborhood boards, and also neighbors, other property owners within 300 feet of the project. And then finally, the DPP will hold a public hearing on the project. So the public will still get many opportunities to see the project and have it presented, as well as, I didn't put on here, but we also post the application materials on our website, and that will also continue. And then I'd like to emphasize that over the last 4 years now, in our close working with the City Council and the City Council staff, who are all extremely talented, we have really focused in our standardized conditions in a way that I think the applicants have some predictability, and it's rare that we deviate too far from the standard conditions. So the kind of standard conditions that we have right now are landowner acknowledgements, landscaping, irrigation, and lighting, and then also I'll emphasize that cultural and historic review, and then State Historic Preservation Division Chapter 6E review will all continue, and we will continue to ensure that cultural and historic resources are protected. The other thing that could happen, depending on where the project is and what the coastal hazards for a particular site are, we could and have, through the City Council, recommended relocation of projects outside of sea level rise exposure areas and flood hazard areas. We have required adaptive foundation design and use of pervious pavement and driveways, and we've required people to minimize fill as much as possible. So now again, because we have these 114 permits that have gone through the City Council in the last 4 years, people are able to anticipate that those are the types of things that are going to be required and have been able to incorporate that into their design early on, which is great. I believe that we've actually made a lot of progress in this way, and I think in terms of time, resources, and expense for single and two-family dwellings, Bill 53 could be really beneficial to the community as well as all of us in being able to really ensure that Chapter 205A as well as Chapter 25 are fully implemented while also saving time. So, mahalo. And I'm available for any questions that you may have.
Thank you very much, Ms. Kruger. Members, any questions for the department? Please, go right ahead, Councilmember Wire.
Thank you, Chair. And mahalo for being here. I was wondering if you could just walk through the numbers again in terms of the processed SMA permits. Have all of those been, those are ones that were approved, or all the ones that were submitted to council, or are those numbers the same?
They are the same.
Okay.
They're all projects that have been submitted to City Council. I will say that just in this past couple of days, I updated the numbers. So there are a handful that we have not yet submitted to you. So
Okay.
I would say maybe 5 or 6 of them are still in our court and are on their way to you.
Okay. And so I'm hearing, it sounds like all the SMA permits that were submitted and recommended or supported by DPP were then subsequently passed by the council.
Yes. There's only the one that City Council currently has where it's the shoreline setback variance and SMA where we're recommending denial. And that's based on the shoreline setback variance hardship standard. It's not so much, it does an SMA analysis, but that's the only one.
Okay. Prior to that, have there been other permits or SMA permits that DPP had recommended denial that were then subsequently passed in your recollection?
Not in my recollection, not since 2020.
Okay.
We have for SMA minor permits. Now, SMA minor permits, there are more than 114 SMA minor permits. I also have the numbers on those, but it's maybe in the 200s. We have recommended denial on a handful of those, but an SMA minor denial is essentially saying we cannot find that there are no adverse impacts and therefore a major permit is required. So it's not so much a denial as you need to go through this other process even though your valuation is less than 500,000.
Okay. And I appreciate that. And I'm asking because I think oftentimes the community's concern is going to be like, oh, this is kind of letting stuff just slip through. And so maybe just a couple more questions. And maybe if you could just kind of elaborate on the either academic, professional experience of folks at DPP that are doing this work and just what it entails a little bit more specifically.
Sure. Well, you've met a lot of our planners in coming up here.
Yeah.
Yep. So Christy Keller, who was just up here for the 2 SMA permits, she has a lot of experience in environmental review. And several of our planners, we have a broad range of experience. We have architects, we have urban planners, we have policy, and public administration people, and then we have environmental planners. And everybody learns together and we there should be 15 planners within the Land Use Permits Division, and all of them will get an opportunity to work on special management area permits. Essentially, they are reviewing the professional documents that are submitted to us from applicants. So they are not creating the analysis, they are reviewing what is presented to us. And that allows the applicant to be providing the flood analysis, say if they need a flood study, they would provide the cultural impact assessment, they would provide the archaeological monitoring plan, those types of documents. And so the planner gets to review those against the publicly available information, say the University of Hawaii Sea Level Rise viewer, We also use the city's Office of OCCSR of Climate Change Resiliency and Sustainability has a web tool that provides all kinds of great information with, anticipated erosion, historical erosion rates. All of those things are evaluated by the planner in light of what's presented to them by the applicant.
Appreciate that. And I'm assuming as these opportunities for public input occur, public hearings or presentations at the neighborhood board, and community members maybe bring up particular facts or newer issues, that would be something that DPP would include in their review and investigation.
Absolutely. In fact, that just recently happened. We have a project right now that has obtained an extension of time before we send it to the City Council, where the community input led directly to knowledge that there are endangered birds nesting on the property. So in that way, the public outreach, the availability of our information on our website, us sending to other agencies, so we send to Department of Land and Natural Resources, to their Fish and Wildlife section, we send to U.S. Fish and Wildlife, and all of those agencies also respond with their information. So in this particular situation, that public input led directly to U.S. Fish and Wildlife as well as DOFA, letting us know that they had confirmed the natives or the endangered species on that property. So in my mind, that really was a great example of a time when all those agencies and the public working together gave us the information we needed to protect coastal resources.
Perfect. Appreciate that, Mahalo. Thank you, Chair.
Thank you. Councilmember Santos Sam.
Thank you, Chair. Liz, I appreciate your comments about having standard conditions, and that's been one of my frustrations with many of the SMA resolutions that come before us. It often seems that the zoning committee chair staff has to do drafts to correct various things, to add in additional conditions. Of the 33 SMAs this year, we have ones that are fairly similar. We have ones for single-family homes in Wailupe, and ones in Waialae, and ones in Portlock, all of which are kind of in the same area, and yet they seemingly have different conditions as they pertain to hoary bats, which I'm not even sure if there are any hoary bats left in Waialae, given how urbanized it is. Monk seals and fill quality, and some have to be certified as free from fungal contaminants for the fill, and others don't. And it just, while I would appreciate giving the department the discretion to approve some of these, it seems to me that we don't have consistent standardized procedures across the board for all of these. And the fact that the council often has to do drafts to correct these things doesn't give me much comfort that the standard conditions are there and that they're being implemented in a way that no one can claim is arbitrary and capricious later on down the line. And so my question to you is, what comfort can you give me that there are standardized conditions, and that if the department is going to be approving these things, we're not going to have to look back later and say, man, I wish we had done this condition or that condition?
Yeah, thank you for that question. Certainly the standard conditions over the last 4 years have evolved. They've especially evolved, things like the fungal contaminants. They evolve in part when our sister agencies give us different information, or when they say maybe that they don't have the capacity to do all of the review that we're asking of them to do. So in those situations, we are continuing to find resources that are available to us to ensure that on a basic level, the construction occurring on a shoreline property is going to have best management practices that are a little bit above and beyond. I understand why it might seem like protecting hoary bats or saying no cutting down trees and giving buffers for monk seals may seem a little over the top for some of these properties, where maybe we don't anticipate seeing monk seals so much on that side of the island as we would on the North Shore or something like that. We, I think, over time have found that the applicants are absolutely willing to do those sort of minimal they don't in reality take a whole lot of time because, of course, if they're not likely to have a monk seal, then they're not likely to have to provide a buffer. But if they do, we want to ensure that that endangered species is protected. So I hear what you're saying. I also want to point out that sometimes it can appear to be arbitrary when in fact those conditions can change based on, say, soil type. So if the soil type is fill and the neighboring property has Jacas sand, we're going to treat those differently because the likelihood of finding an archaeological resource in Jacas sand is so much higher than it is in fill. So, or, maybe one property has sea level rise exposure, but it's not erosion-based exposure. And if we anticipate sea level rise will result in erosion of that property, then we're looking at whether the ocean will actually be under the house versus that house might have annual wave action periodically or something like that. So it can often turn on something that doesn't seem that important, but actually in our analysis is. So I personally believe that our staff planners do a lot of really great work. I do appreciate the city council staff helping us and continuing to work on these evolving conditions. I think that we can do an effective job, and that's what I'll say on that.
I appreciate the very detailed and thorough explanation, so thank you.
Members, please proceed. Representative, Councilmember Wire.
Thank you, Chair. I just had a quick question, and I don't know if you have perspective on it, but I know with the major, like you mentioned, the public hearing was a part of it. I was just curious if you would see any challenges with reducing the threshold for a major, or not a major, but in terms of having a lower threshold for a neighborhood board presentation. Maybe if it's a minor but meets a certain threshold, like say $250,000, but doesn't require all of the other, public notice, public hearing at the broader level. And I just ask that because I think community members, particularly neighborhood board members, have brought up how oftentimes they feel like projects come in and are represented in a certain way to fall below the threshold and to avoid triggering the major, and oftentimes they feel like they have have insight or experiences or firsthand knowledge of the situation to be able to share that.
Sure, yes. So when a project is less than $500,000, it can be reviewed as an SMA minor, and SMA minors don't have all of those public input requirements. So we review their anticipated cost. The project valuation is required to be produced by a third party, so not the actual project contractor or anything. And they do a line item where they produce everything. You're right that a lot of the times it might be in the upper 400,000s. That could be for two reasons. On one side, maybe they pull a project back until it's less than 500,000, or it could just be that that's the cost. It may be that they're trying to shield it from getting the major process. That said, then when the building permit comes in, it also has to have a valuation. So if the building permit comes in and the valuation is suddenly $1.1 million, then we're going to say that the condition of the SMA minor permit says if it ultimately exceeds $500,000, you have to stop everything and come back in for the SMA major.
I appreciate that. And I won't go on too long, Chair, just last. So for an SMA minor application, what would be the public's notice, or what would be their best way to find out? I know they can go look on the DPP website and search by property to see kind of like, oh, what's going on over there? I saw some activity. Let me go see if they have permits or an application in. But is there another type of notice that occurs earlier on in the process?
There really isn't an SMA minor notification process like that. We do send all of our SMA minor decisions to the Office of Planning and Sustainable Development at the state, and they have that list published in the environmental notice every month. But yeah, otherwise, I mean, that's one of the big differences with Act 16. Before Act 16, most SMA minors were really minor because they were, a commercial property adding part of their, parking lot or adding a small addition or putting in a fence. And then all of a sudden it became these residential, a brand new single family home or something like that. But that said, we don't do a lesser evaluation related to the objectives, goals, and policies of the Coastal Zone Management Act. We still look at each of those individually and assess impacts. So although there isn't as much neighborhood notice, we still go through a real procedure.
Okay, because I appreciate that, because I'm wondering if because a presentation might be a lot, but maybe at least some type of notice to say like a neighborhood board, if it's under their jurisdiction, might be helpful for the community to feel a little more heard, because I think DPP is doing an amazing job. The team reviewing is doing their due diligence, applying the law, and of course our enforcement folks, I think we're working on identifying better ways to staff and support and tool, but I think everyone's still working hard and shows up and turns out to go and do the investigations, and so appreciate that. But just that's where the nature of the questions are, where the questions stem from. Thank you, Chair.
Thank you. Councilwoman Cordero.
Thank you. Sorry, Chair. I know that you probably couldn't see me in the first round, but I was raising my hand. But I'm glad that I'm going after the second round, since Councilmember Dos Santos Tam was able to ask a few of my questions. But in addition to those concerns or questions, my next question would be, when design changes are required by the department to the applicant, would the public participation process occur again, such as going back to the neighborhood board or having to do a public meeting about the design changes?
Thank you for that question. At the moment, no, there's no procedure to go back to the neighborhood board. The applicant would be required to meet all of the conditions of approval before obtaining a building permit. But yeah, when the city council has adopted resolutions that require relocation outside of the sea level rise exposure area, they have not also required the applicant to go back to the neighborhood board of the area.
Okay, thank you. And currently, when the developers or the applicant themselves come before the council, they do share their public process of, here were the comments, such as, moving the gate instead of going outward into a parking lot inward, for example. How then would we be able to see that the recommendations or requests from the department or even from the public process were taken into consideration?
Yeah, thank you for that question as well. In our reports, there's a section where we discuss the neighborhood, both the neighborhood board meeting as well as the public participation overall. And in that section, we summarize the written testimony as well as verbal testimony at the public hearing, and then discuss whether any comments were given that would relate to a design change or something like that, and then discuss whether either the applicant agreed to something and it's reflected in the plans, or if we're requiring a condition of approval to show that they were meeting that requirement. So that's generally how we would address that. And then I understand that there are a handful of CD1s of Bill 53. All of them would involve the department sending copies of the approval or denial with conditions to the city council for review.
Thank you, Ms. Kruger. And my last question is sort of a more simpler question. It just, your first mention of making the process shorter and less expensive. I know it may be shorter and less expensive for both the city side as well as the applicant, but would you be able to share a bit more how less expensive it would be both on the department side as well as for the applicants.
Sure, I can discuss that a little bit. I personally don't know exactly how private consultants bill their clients, but I do understand that the longer the procedure and the more public meetings there are and the more hours that are likely to be required to finish the project, they will charge the client more money. So on one side, just in terms of expense, there's that basic expense up front. Then of course there's the time is money element of if there's less certainty and a longer time frame, then construction loans and that kind of thing can get very expensive. So just from a fundamental perspective, one of the reasons that when Ordinance 23-4 was passed for this ordinance, they, 1 and 2 family homes were not required to do environmental assessments for some of these same reasons, that it was increasing the cost of housing and making it more difficult for those landowners. And then in terms of the department's time and expense and the city council's time and expense, I think that from the department's perspective, we don't mind coming to the city council. We come to you often for all of these projects. We enjoy working with you. We definitely want to make sure that we, given our limited staff, focus our attention most on the most important projects. I don't have a number for how much I think that time and money we spend on all of these single and 2 family dwellings coming, but I do think it's almost more our ability to focus our attention on projects that are potentially more likely to have environmental impacts.
Thank you. And as for the shortened process, how many months or years do you believe that it will shorten the process?
Sure. So the procedure as it's laid out in Bill 53 would essentially end at the point that the department currently sends the recommendation to the city council. So the time period that is shortened is the time period between our transmittal and then the committee scheduling and then the full council scheduling. So that might be, if the council is required to act within 60 days unless an extension is required. So you could say that on average, they would save about 60 days.
Thank you. And since I mentioned that Councilmember Dos Santos Tam asked a few of the concerns, or maybe I shouldn't say concerns, but points that I would have brought up. One example that I wanted to add on to his examples, he used 40 bats, but I want to use one of our colleagues, Council Vice Chair Kia Aina, when she would ask about when people place pools or, either extend a pool into another part of the area. How will we have that same assurance or query to the applicant or the owner or their representatives to this process?
Yeah, I think when it comes to like a swimming pool where the concern is that they're digging, right? Is that what we're talking about? Where we're digging into sand and concerned that we'll hit cultural resources, potentially iwi kupuna, and that sort of thing. I think that the assurance is that right now, the mitigation is that things are being sent to the State Historic Preservation Division for consistency, for a determination of consistency with Chapter 6E. That will continue. That relationship between DPP and SHPD will continue. And in addition, we're continuing with our Oahu Historic Preservation Commission and our recent certified local government status through the Department of the Interior. We're continuing to improve our cities and counties' ability to be reviewing for these cultural and historic and archaeological resources. So in that way, I feel confident that we will be able to ensure that potential impacts are mitigated. We will continue to seek out the expertise of other agencies, and will be very responsive to any city council member questions.
Thank you, Ms. Kruger. And my very last question is, during this process where the city council has had to take up SMAs, are there any parts of the process or queries by the council that DPP has added to their process that they've taken from the council? I don't know if that kind of makes sense. I guess things that the council members or council has brought up during our process that DPP is going to be adding on to the SMA process or standardized SMA process.
Yes, absolutely. I think that the last 4 years of interacting closely with council members and staff has helped us very much understand what is important to the council members, particularly when the community speaks out about certain things. I think that one of the things that we've learned from the city council is what you're talking about with these sort of consistency of the conditions. The city council has really signaled pretty loudly to the development community that when something is in the sea level rise exposure area, they're fully willing and ready to require resiliency measures, and that I think is something that we have very much taken to heart, because it increases the likelihood that these dwellings will be able to live out their full time period without being destroyed or overtaken by any kind of coastal hazard. And that's where we have really appreciated the city council's work in this sphere.
Thank you, Ms. Kruger. Thank you, Chair.
Thank you very much, Councilwoman Cordero. Members, any other questions, please? No other questions, okay. Being the sponsor of this measure, the concern was what we have talked about in the past, the overall processing of the SMAs and other building applications. This morning's discussion was focused primarily on the SMA, the Shoreline Management Act, which was enacted by the state legislature, mandating the counties to do this, this, and this. During the past, I would say 2 years, as far as my experience, we've seen more and more of these type of applications come before the council. You know, but most of them are the majors, and what was stated for the record, the 114% increase, as I can't say it has affected the morale or the operations of your division, but you know, at some point in time, they can only do so much per year. And you know, Liz, what are your thoughts about something like that? Because we're just trying to make it efficient. Everybody was criticizing government that we were inefficient. DPP was inefficient 4 years ago, and this is just going to be another hamper of maybe saving 60 days. Tough, because of the environmental concerns that we all have. So it was introduced for further discussion, but I needed you folks 1 hour too, you see. So that's why we are having this discussion. Tyler, your thoughts, you know, for the SMA program, which is a state, you know, law that mandates counties.
Yeah, I think you've hit on exactly what the point is. The state tells us what to do, and then it's up to us to figure out how to implement it. But, you know, I appreciate Liz's thoughtful response because, as you pointed out, we have a responsibility to make sure that when somebody's doing something near shoreline, it's done in a way that makes sense, that follows all the rules. And so hearing her detailed response on some of these standard conditions makes me feel a little bit better about giving them the ability for these very small projects so that we can focus on the bigger ones.
The minor projects.
Yes.
Your thoughts, Matt, and then followed by Val.
Yeah, no, I share those sentiments. Appreciate the thought, appreciate the work of DPP and Liz and everyone on the team. And, I do think that it's, at the end of the day, our expectation of the community and folks that are doing projects is just that they have to comply and follow the law, right? And I do believe that the planners at DPP are positioned to evaluate the facts, apply the law appropriately, and then make decisions. I think, I am always looking for ways for community involvement in the sense that the more facts we have and the more perspective we have, the more complete the evaluation can be, right? I don't want to politicize processes. I don't want to make it into something that's not supposed to be, but just recognizing that there's so much knowledge, historical knowledge in our communities, our very diverse communities. I do always welcome opportunities for that, but in terms of setting up a process where we streamline the SMA evaluation, I think it's a step in the right direction. Yeah, so appreciate your work, Chair.
Thank you. Councilwoman Okimoto, followed by Cordero.
Thank you, Chair. I want to thank you. You shared a lot today, and several things that you shared really had me thinking. I do understand, Councilmember C has been really a great educator for all of us, and when the state requires us to do things, then we have to pick up the ball and figure out how to abide by it or comply by it. But one of the things you really mentioned that stuck with me, and it'll help me to be more mindful in our positions, is that with the limited staff that you have, and we do require you guys to come and explain, because we want to have the information out to our communities. This is one department that is more under scrutiny than others, at least in my community's eyes, where I constantly get asked questions about it. But thank you for sharing that in the event of us having you come here, and you guys are always willing to come and educate us, that it does take away resources that are then in the department. So that's something that that stuck out to me, that I want to be more mindful of. We want to get the information out to our constituents. We want to make sure that we're following up and that there's that the lines of communication are clearer. But I think it's good for us to be mindful that in us doing so, what can we do to then not affect what you guys are doing, because you are required to now do even more things based on the mandates that the city is that are being placed in the city. So thank you for doing that, and I'll continue to, in my office, and I will continue to work with you guys. But thank you, Chair, for this forum to have us be more informed and educated.
Thank you. Oh, Councilwoman Cordero, please. Radiant.
Thank you, Chair Say, for introducing this bill. I am in strong support of this measure. I am very happy that you've done so. I do have to say that even with the minor projects, it's interesting that we see, I guess, what other people do with their properties and projects, and it just showed me another world other than the major developments that DPP deals with. So thank you very much.
Okay, thank you. Right ahead, Councilmember Wire.
Thank you, Chair. I just want to know, I think phone number 9 ending in 9120 was on at some point wanting to provide testimony. I'll defer to the clerk whether they're still on, but just wanted to bring that to the committee's attention.
Okay, thank you very much, Liz. Let's proceed on and see what we come up with. Okay, Madam Clerk, are there a testifier online?
Yes, Chair, there are.
Okay, last 3 digits, 120. Okay, please. 120. I see it right there, the phone. Good morning.
Hello, can you hear me?
Yes, yes.
Hi, good morning. Mahalo, Chair. Raquel Achu. Wailua Moku. I just wanted to address a couple of issues with the SMA that can hopefully be considered. Mahalo to Councilmember Wire for his input earlier as well, very on point. Also to Councilmember Cordero, who also pointed out the issue of when there are changes. They're never brought back. Although I am testifying as an individual, I do sit on our neighborhood board, and my experience has shown me that there is a lot of room here to consider. First of all, SMAs, in my opinion, should consider an expiration, because sometimes these things can go on forever, and by the time a project starts, a lot of time has passed and a lot of consideration needs to be replaced into that project. A trend here also is people starting their projects without their approval and just coming in later. That is ongoing out here. There's no good project out here that comes out. Many come out starting as a minor, and because those changes don't come back to us, they end up majors. Personally, I think every project, regardless of minor or major, should come through some kind of advisory or oversight, whether it be through boards, associations, or the council. We're on our shoreline. We've got so many issues out here that really require oversight through the process. We are inundated with craziness out here. I'll just say that. I do commend DPP and Dawn and her team for really the great improvement of work that's happened. Our relation with them has been very positive. All of our concerns are being addressed, which is very, very encouraging for us. But we do believe there's room here for some additional consideration. The reduction in the value, no one's certifying those values. So we actually have had contested cases in recent of valuation saying, oh, this project's going to cost me $250. There's no way anyone could have looked at that plan and said, oh, okay. It didn't end up that way.
Okay.
So we have a lot of those types of issues, and I will submit them as well.
Thank you.
Thank you.
No, thank you very much for your participation. Ms. Angela Young?
Aloha, council member. Say, can you power on my video? Do you have the power to power on my video?
No, we don't.
Oh, thank you. Yeah. Wanted to see you because, you know, it's the end of the year. Okay, all right. So it's such an honor to serve with you, Councilmember Say. I just want to say, okay, so if my time has started, I'm going to testify in favor of the ordinance. So special management areas from the Office of Sustainable Planning and Development defines coastal zone management priorities to protect shoreline beaches and waters through the development process. Coastal zones are geographic locations where land and ocean meet, and the zones are vulnerable to hazards due to high energy and reaches the coast during storms. Special management areas, thank you, in coastal zones have many species to protect, such as dolphins, whales, and turtles. And although legislated by Hawaii state law requires the counties to process a permit to build in the special management areas statewide, single-family houses, organizations, entities, developers with private clients undertaking development within the SMA, which will require a major or minor permit, will seek an application process from DPP. So it's DPP's purview to process permits within the Honolulu County. And so DPP's office provides guidelines for reviewing developments and SMAs, including ensuring adequate access to public beaches and reserves, and allows fines for up to $100. I will summarize, okay? So because the statutory parameters of environmental protection of natural resources is a specialty knowledge, I don't think it should be up for discussion for the neighborhood board, major or minor permits, period. So because there's also statutory civil fines of $100,000 for violating.
Ms. Young, thank you very much, Angela.
Great, thank you.
I believe that was in strong support for the measure. Okay, members, Madam Clerk, are there any in-person testifiers? Okay.
Yes, Chair, we have one standing by.
Please.
Yeah, hello, Jim Hayes. Excuse me. Planning and permitting consultant. I think you are familiar with me coming before the council on a number of SMA permits, both the type of residential permits that are being considered with this bill, and also the more major permits, including beach park developments and things of that nature that will continue to come before the council under this bill. And I would just like to say that we support this bill, and I work carefully with my clients, closely with my clients, to ensure that what they bring to DPP is going to be something that is permittable. And as part of that action, we do have pre-application meetings with DPP staff. And this is months and months before the projects ever come to you. And then based on those interactions with DPP staff, we make adjustments to the project and ensure that the project complies with SMA, with shoreline setbacks, with land use ordinance, and all of those elements so that they are permittable. Having these standard conditions, which have become more standardized over the last few years, make the process predictable for our clients, and they very much appreciate that. And I would say lastly that I think a lot of the variation and difficulty is going to subside now that the new shoreline setback is in place, and there's no longer like some question, oh, did you get your permit in advance and you're doing a 40-foot setback instead of a 60-foot setback. Now that that transition is complete, I think that it'll be much more easy for DPP to manage these permits.
Okay. Jim, the thought was, so how long does it take from the point of the developer or the financier or the private landowner say, Jim, let's go for it? And the process starts from that point, but how does it work so that we know how long or difficult it may be or may not be difficult?
Yeah, it can be a very involved process, and it starts with the shoreline certification. So the shoreline certification is the first element that's required, and that goes through DLNR. And so the owner has to have a surveyor come out, and then that's submitted to DLNR. It goes through an environmental review with DLNR. That process alone can take 5 months or longer. And then during that time, typically we go to the neighborhood board and are preparing our SMA application, and then that gets submitted to DPP. We have the hearing, they write their staff report, et cetera. So before these projects get to you, it can be a 10-month process if you include the shoreline setback, or if you include the shoreline survey. Some projects, they've already done their survey, you know, like if there's been a recent sale of the property, for instance, oftentimes the shoreline is certified at that time. So sometimes that is already in place. But having a process reduced by 60 days is a substantial benefit to the applicant. And like Liz said, I think time is money. And having a little more certainty and understanding of the process. And quite frankly, I'll say that of all the elements in the process, one of the things that kind of doesn't scare, but you know, that causes concern and consternation among the applicants is coming before the city council, just because they haven't done things like that before. And so it takes some coaching about how the process works. But you know, that's something that we typically handle. And then, you know, like just it will be a cost savings if this proceeds, in that the agents like myself won't have to come before the city council. We'll still be interacting and going to hearings and neighborhood boards and things like that, and interacting with DLNR or DPP. And DPP, they don't go easy on us, right? I mean, they know what the priorities are to protect the shoreline. They live in the community as well. And, you know, it's not like an easy ride just because this bill would pass.
Okay, Mr. Hayes, one final question for the chair is simply put, if you were in my position, why would Calvin Say and Jim Hayes give up the authority we have for minor projects, minor SMAs? You know, just for discussion purposes,
For minor,
minor SMA permits.
so right now the minor permits stay completely within DPP.
Right.
Yeah. You know, even with minor permits, just the other day, I had a minor permit that we were working on with DPP, and they came out and told us, look, we're probably going to deny this permit. And I said, okay, then let's pull it back. And so we just didn't proceed with that project. And so we have that kind of relationship where, you know, if the DPP comes out and says very specifically, like, this is not going to be something that we can see going forward. And that can relate to swimming pools or things like that. That's something that Councilmember Kia Aina brings up frequently, swimming pools acting as a seawall in effect. So we advise our clients against seawalls on the shoreline side of a residence, or adding swimming pools after a project has been developed. But I think the SMA minor process, anything under $500,000, you can't do much for under $500,000. So I think that the process is substantial and significant as it stands today.
Okay, thank you. Okay, Councilwoman Cordero? No? Okay. Liz, your thoughts? Come on, Liz, share with us, you know, you're the processor.
My thoughts overall on the bill?
Yeah, just person.
Well, I'll say that I've had my own growth over the last 4 years. When Act 16 passed, we were sort of flabbergasted. We were in the middle of COVID. All of a sudden, our workload was going up kind of overnight, and we suddenly found ourselves scrutinizing a residential floor plan when what we were used to was things like, you know, beach park restoration projects and that kind of thing. And at first I thought this was going to be a waste of time. And then as project after project came in, we found that we were able to provide value-added feedback to the applicants. We were able to provide a rigorous analysis that would result in more resilient buildings, more resilient design plans, more resilient residential lots. And so I came to understand how important that individual lot by lot analysis was. I do think that it takes a lot of time. I think sometimes it seems like we get a bunch in all at once and every planner is stressed for the next, you know, whatever it is, the 45 days after the public hearing closes and that kind of thing. So knowing that they still need to do all of this work, but it won't result in sort of a further process will help us. I do think that we can do an excellent job. I think that we have been doing an excellent job. I think, of course, there's room for growth. We are constantly looking for more data, more information from the Federal Emergency Management Agency, more information from the University of Hawaii. We have really great relationships that have grown stronger with our sister agencies at the state and federal level. And I guess in that way, I'm really hopeful because I believe that this type of shoreline resiliency is going to be very necessary, especially as we watch things like the storms in Florida that really just have affected individuals. So I think that Bill 53 will allow us to save time and effort, but it will not result in a lesser evaluation, and I don't think it will result in a lessening of the quality of the SMA major permits that are issued.
Okay, any thoughts for Liz? One final thought is the fact that some of our testifiers have stated for the record on Bill 53 that going through the administrative process, you're limited in your transparency and hearing process. Is that true? Because I think you folks have done a great job on major projects in District 5 that you folks have gone out. But then there's others that say, oh, we didn't get to see you folks, and so forth. But your thoughts on that too?
Well, I think that we're doing a lot of things to make the public access better than it was. So in the last couple of years, we have a new spot on our website with an interactive map where you can click on a dot and that shows you the application materials for that project, which is really cool. And that kind of thing is only expanding our ability to use technology. The other silver lining of COVID is that now almost all of our public hearings, as long as they're held in facilities that have the capability, are being broadcast over WebEx or Zoom so that the public can participate even if they can't come in person. We have a lot of ways for people to provide written testimony. And then, in terms of the change that would happen with Bill 53, it would be a day like today that they wouldn't have. So, most of the time we haven't gotten too much public testimony at the city council level for these 1 and 2 family homes. But that is where that's the one time that right now there's an opportunity for testimony that would not be there, depending on which mechanism or which CD1 is approved.
Okay, thank you. Any further questions, members? If not, Madam Clerk, are there any more in-person testifiers?
Chair, there are none.
Okay. If not, members, we are now in discussion. Any discussion? I think we have a very thorough, well-educated discussion. So at this time, the chair would like to recommend that action on Bill 53 of 2024 be postponed to a time and date to be determined by the committee chair. And I'll try to solicit input further from the Department of Planning and Permitting and other individuals who are interested in the measure. But that is the chair's recommendation. Any discussion?
Chair.
Yes.
Yes, discussion. So your postponement is you're going to add further amendments to the bill?
Yes, but very, very little as far as the amendments. I was looking at the concern of some of our residents about, would you folks be open to a 8-year legislation with sunset in 8 years, so you folks can review it, or the future council members can review it, because that impacts Liz, folks. But this is a discussion I wanted to consider having with you folks when that particular committee draft is. So
okay, thank you, Chair.
that was about it. I can sympathize with both sides, and today it was a great discussion because we as a council are trying our best to improve the efficiency of the applications that come in. But we also have to be cognizant, I think Matt Wire stated, that the environmental side too. Yeah, Matt?
I appreciate that. And of course, I'll defer to the chair, but I just wanted to note that I think it's good legislation. I think you put a lot of thought into it. I don't think I would necessarily feel inclined to ask for a sunset, because I know that future councils can always revisit it. And I think you rightly have relied on DPP and their expertise. But yeah, I'm open to suggestions. So I do think that,
Okay.
yeah,
great.
so, yeah.
Radiant, how about you? And then Tyler, your thoughts. Radiant, any other thoughts? Or would you want it to be adopted the way it is? How's that? I just wanted to postpone if I could draft that.
I think it's fine moving forward.
Okay. Matt, Tyler?
Thank you. I don't have strong feelings either way. I'll note that 8 years from now is a long time, and perhaps there will be 2 departments in 8 years, a Department of Planning and a Department of Permitting. We'll see.
Okay. The chair would like to reconsider his statement that he's made publicly, that the chair then would like to reconsider my statements made about the postponement, that the chair would like to recommend that Bill 53, 2024 be amended to the posted committee draft 1. And that's it. Any discussion? Oops. Yeah, Chris. Was it CD1?
Yeah, on
Yeah.
the agenda or the addendum, because there's two.
The CD1.
On the addendum.
That's the one. Right. Okay. Can we have a short recess? Recess subject to the call of the chair. Okay, I'm very, very sorry. At this point in time, we do have two drafts. And at this time, not going over the two drafts correctly, the chair would like to recommend, I made the motion earlier that we're going to postpone and work on what we had wanted to do. Okay? So the chair at this time recommends that action on Bill 53 of 2024 be postponed to a time and date to be determined by the committee chair. Yes. Any discussion, objections, or reservations? Hearing none, so ordered. So we will take it up. And finally, moving on to agenda number 9, which is Bill 31, 2024. And this is a bill for discussion purposes for this year that we'll try to address. This bill relating to the pre-construction financing for affordable rental housing. Members, we have posted to the agenda proposed committee draft 1 versions of the bill, 2 submitted by Councilmember Wire, and 1 that I submitted. For your information, summaries of the amendments are listed on the agenda. We have also distributed a hand-carried proposed committee draft 2 submitted by Councilmember Dos Santos Tam. I will first defer to Councilmember Wire to explain his CD2.
Thank you, Chair. And mahalo for pointing out the multiple. I believe that's referring to the 250 and the 300 square foot difference, but just largely our amendment was setting the flat rate for 300 square foot and above, understanding the need to conform with Bill 3 that passed out earlier, and setting the dollar amount for below that to either 83 or 83.33 per square foot, acknowledging that for a pre-construction grant program, because of the Hawaii revised statutes, projects would be subject to prevailing wage requirements, which is a good thing, right, to ensure that we're supporting our local workers. And that was the bulk of the amendment.
Okay, thank you very much. Councilmember Dos Santos Tam.
Thank you, Chair. My version uses your proposed CD2 as a basis, but has a few key differences. In my version, my version specifies that you cannot receive a post-construction grant if you've already received a pre-construction subsidy for the same affordable rental housing project. Those words, "for the same," I think is important because as it's drafted now, it seems to imply that if you've ever received a pre-construction subsidy, you'd never be able to receive a post-construction grant, even for a different project. And then the second changes that I'm proposing is to take out the provision that pre-construction subsidies may only be used for the purposes of paying prevailing wages to every laborer and mechanic. It's taking that out and putting in a requirement that the developer adhere to Chapter 104. As written right now, it seems to imply that the same dollar that you receive from the city must then go to the contractor, then to the subcontractor, and then to the worker, which creates a sort of compliance headache. On the state side, when they do these sorts of contracts, they simply require adherence to Chapter 104, and if you don't, they claw back the funds. So I'm not sure if that specific language that the pre-construction subsidies be used for this is necessary. And then finally, my version takes out the annual reporting requirement from the developer to DPP about Chapter 104, because Chapter 104 already requires weekly reporting. And so the annual report might be superfluous to the 52 weekly reports.
Okay, thank you very much. And my proposed draft 2 would just make it for affordable rental housing units that is less than the 300 square foot in size, provide for a pre-construction subsidy amount of 83, similar to Councilmember Wyer's per square foot outdwelling unit per floor. Then we make conforming amendments to the post-construction grant provisions to provide that any given fiscal year, no more than 50% of the monies appropriated may be used for pre-construction subsidies and no more for monies appropriated for post-construction grants. That was it. So that both sides, the small guy and the big guy, get some amount of money. Councilwoman Cordero, any thoughts on the first 3 different committee drafts at this time?
Well, first off, thank you. Well, Chair, thank you to all 3 of the introducers of the CD1s, of the CDs. I do appreciate Councilmember Dos Santos Tam incorporating both of your amendments. So, well, not all the amendments, but also taking the redundant reporting requirements into consideration. So I do support his draft, but I overall support all the measures taken.
Okay, thank you very much. Any other questions, members? Not, then we can proceed on with the testifiers. The Department of Planning and Permitting. Liz? Oh, Denise, Director of Housing.
Good morning, Chair Say, members of the committee, Denise Sari, Matsubara Office of Housing. So I just wanted to offer some comments. I know that this is for information only. And first of all, Office of Housing strongly supports a pre-construction subsidy because we believe that the subsidies are needed on a pre-construction basis to help projects move forward. The thing that we wanted to point out is something that we discovered fairly recently, in that these projects now qualify and are awarded low-income housing tax credits, as well as state rental housing and revolving funds as subsidy. So when that starts to happen, in order for subsidies not to affect the eligible basis on a low-income housing tax credit project, it's probably going to reduce the state subsidy, and this will have to take its place. But the more important consequence of this is that it lowers the AMI threshold such that folks earning at the 100% AMI, so for individuals at $97,000, and for couples at $111,000 who would normally qualify for these projects, would no longer qualify. And some of these the workforce include folks in our hospitality business, and also project has received a LIHTC award that was permitted as.
The grant program, am I understanding correctly?
That's absolutely correct. Once you start using the housing tax credits, then it automatically brings it down to 60% AMI.
Okay. And whereas under the grant program, they're able to build anywhere up until 100 AMI.
That's correct.
Okay. Does Office of Housing have a preference on approach? Would it be just excluding LIHTC funded projects from the grant program?
That might be one consideration. I also noticed that it is possible for these projects to also get affordable housing funds. So that would also lower the AMI threshold. So subsidy layering is not new, right, to housing, but the fact that this Chapter 32 is one of the only programs that we have really for the more moderate income renters, and the fact that our projections, according to our housing consultants, are more, projected growth is going to be for the more moderate to higher income levels. I think that would be a concern for us, but one of the approaches to help address that would be to kind of consider a condition that these projects may not be subject or may not be eligible for those funding sources that would drag that AMI threshold down.
Okay. And I'm just curious because if other grant programs, so I mean, I guess first, is it housing's preference that the AMI allowance under the grant program be increased to 140% AMI? Or is that kind of outside the scope of what we're talking about? Because I know we've discussed before, and maybe there's differences of opinion about like, oh, is this primarily targeting workforce housing, or is it primarily targeting urban infill projects at whatever AMI is feasible or pencils out?
Personally, I think it would be wonderful if the rent could go up to 140, but I think Chapter 32 stops it at 100% AMI.
Okay. Mahalo, appreciate that. I did have questions for DPP, but I'll defer to Chair if you want that after.
Okay, no, go right ahead, please.
Yeah.
Is Liz here?
Yeah, mahalo. And I just was curious, because I know we have a lot of different, mahalo director for that, programs and opportunities for folks to build housing in different areas, including like say TOD or, other parts of the community where maybe there's certain trade-offs or maybe additional height or density can be allowed with community benefits. I was just curious, based on your understanding of this program, are we looking at this allowing greater height than the underlying zoning? And I bring that up because I know there's some concerns that have been raised about the types of projects that are going to pop up in the community. And so I'm just trying to wrap my mind around like what this is actually allowing.
Sure, thank you for that question. I'm Elizabeth Krieger, Department of Planning and Permitting. So-called Bill 7 projects, which is now Chapter 32 ROH, are allowed only to a height limit of 60. So in certain areas, it may be the case that the underlying zoning allows more than 60, but in other areas, 60 is additional height. So especially like in the A1 apartment district and some A2 apartment districts, they may not have a 60-foot height limit. And so in those cases, Chapter 32 does allow that kind of increase in height. It allows some increase in density, but it provides caps. So unlike a 201H project, the 201H can come in and say, please change these certain development standards for this project for the production of affordable housing. And the city council is allowed to look at any of those, provided they wouldn't affect health and safety. With Chapter 32, there is a limit within the ordinance, and I don't have it off the top of my head, but it's 60 feet. It might be a floor area ratio of 4.0, which is higher than most of those underlying zoning districts. And then it allows other things like a smaller required yard, not as much landscaping. It doesn't require parking, even if it's in a district that otherwise would require parking, that kind of thing.
I appreciate that. So I think I'm hearing you say that it caps the height and density, which may at times be below what the underlying zoning lot allows, and then sometimes maybe above.
That's exactly right.
Okay, thank you. Appreciate that. Thank you, Chair.
Oh, okay. Go right ahead.
Okay, thank you. Building off your last point, and I know that there's some testifiers who are going to be speaking to this, I wanted to ask, so, there's a hierarchy of sort of plans and zoning and other rules that apply to any particular parcel around the island. Chapter 32, does Chapter 32, as currently written, supersede things like a special district, things like the underlying zoning height, which you kind of talked about? Does this basically supersede almost every underlying condition that may apply to the parcel?
It does. It didn't originally supersede special districts, and then it was further amended to supersede special districts. There are spots where it is silent, and in those situations, the LUO comes in to say where it's silent, LUO can be used. But essentially, as a developer, you need to choose one. You can't kind of blend those two development standards. If you're choosing Chapter 32, those are your parameters.
And then for Chapter 32, are there any geographic restrictions as to where it can be done around the island?
I don't think so, but I would have to look into the code again just to ensure that that's true. There are zoning district restrictions. It is not available in the residential districts. It's not available in the apartment districts, or I'm sorry, residential, agriculture, not available. It's not available in the industrial districts, and I don't believe it's available in the straight business districts.
Okay, that's all my questions for Liz. I do have questions for the director of the Office of Housing, but we can get to her after.
Councilwoman Cordero, any questions? No. Okay. Why don't we call upon the housing director? Councilmember DeSanto Sam.
Thank you. I appreciate your comments about the layering of funding sources. Obviously, the creation of affordable housing is very complex. You mentioned LIHTC as being one of the sources of funding that requires a lower AMI for all of the units. I wanted to ask about some of the other programs that are available. You also mentioned the city's Affordable Housing Fund. Are Bill 7 projects eligible for things like DERF or Rental Housing Revolving Fund based on your understanding of those criteria?
Well, I think the fact that one of the Bill 7 projects has already won an award for rental housing revolving funds is a testament to that. I would imagine that if they qualify for rental housing revolving funds, they might also qualify for DERF funds as well.
And I guess that's kind of, Chair, that's where my line of questions come from, just because there's so many funding sources available. And I understand the concern of LIHTC because that's targeted at a specific audience. Bill 7's targeted another. But with a plethora of programs, it becomes very difficult for us to say, well, not this program, but you can use these other programs and this other one with certain conditions, right? And there may be some other program that the state legislature creates, and then we're going to have to figure out what to do with it.
Any further comments? Councilmember DeSanto Sam. Okay. Anyone else? Okay, let's start off with the remote testimony, Madam Clerk.
Chair, there are none.
Thank you. And then next, let's move on to the in-person testimony.
Yes, Chair, we have one standing by.
Okay. Mr. Bailey Matsuda.
Aloha mai kako. My name is Bailey Matsuda, and I'm here on behalf of myself and my neighbors on Alapa'i Street. We, like all of you, are supportive of affordable rental development in Honolulu and supportive of our unions. And we strongly feel that affordable rental development needs to be done in a responsive, and respectful way. Bill 31 by itself would be a good idea if it funded first-time home buyers, for example, or small to medium projects that were compliant with city land use ordinances and zoning in our neighborhood. But Bill 31 is connected, we feel, to a flawed process. Bill 31 is slated to use $10 million from the general fund, that's my tax money, to potentially fund Bill 7 projects by investment companies like Paul Lamb Capital LLC that do not need the pre-construction grants. In 15 years, the low subsidized rents from this potential tax-supported project will revert to market prices. What happens to the people who will be displaced when this happens? Let me conclude. Your own ordinances and plans protect and preserve the unique character and culture of our Aina, yet you allow the overreach of Chapter 32 and its possibly inappropriate Bill 7 developments to bypass these protections, potentially altering our special districts forever. Mahalo for your consideration.
Thank you very much, Mr. Matsuda. Any questions for Mr. Matsuda, members? If not, nope, thank you.
Okay, thank you.
Madam Clerk, are there, okay, please, come on up, state your name for the record.
I'll be short today, everybody. My name is Ann Smoke. I also live in the Punch Bowl Special District. Good morning, Chair Say, and good morning, Chairman, Councilmember Dos Santos Tam, and the other city council members who are here today. I'm in favor of this bill proposal to provide pre-construction subsidies for sustainable, affordable housing. However, these subsidies should be prioritized for first-time owner developers who are otherwise undercapitalized and are most likely to construct smaller scale projects that are better fit for the character and needs of certain residential areas. By contrast, the larger investor developer entities that have already entered the affordable housing market, some even funded by wealthy investors, perhaps do not require further financial incentives beyond what's already been afforded. A few Honolulu residents, including myself, submitted written testimony suggesting that Bill 7 be amended so pre-construction subsidy agreement reflect the subsidy amount received by the owner developer and will be filed with the Bureau of Conveyances. With respect to any large-scale rental housing projects, the amount of the recorded subsidy will be a conditional credit that will promptly be remitted to the city by the owner or its successor in the event that the project at any time ceases to operate as an affordable housing project within the meaning of the ROH Chapter 32. This provides some degree of incentive for the projects to continue as affordable housing after completion of its mandatory 15-year period. Alternatively, if the project is no longer operated as an affordable housing project, it's either sold or converted to market rental sale, the city should be entitled to recoup its subsidy, given the likely profit to be realized by the owner. That money could be applied to new initiatives that will be needed in just 15 years when the developments currently being built convert to market rental and all of the low-income residents are displaced. So thank you for hearing my testimony.
Thank you very much for your attendance. Members, any questions for Ann? I got to see her testify at the Makiki Neighborhood Board.
Thank you. Yeah. Thank you.
Members, any other questions? Any thoughts from the Director of Housing? Ms. Matsubara, you and I have attended the Makiki Townless Neighborhood Board, and you can sympathize maybe with some of our residents about, what they have said, and maybe you could come up with some ideas of how to resolve it. But the issue of Bill 7, Vice Chair Dos Santos Tom, that was before our time. That was adopted, and we just tried to follow up on it. But there is a sunset date also on Bill 7. So I can understand, Ms. Cordero, Councilmember Cordero. Any other thoughts? You weren't here, yeah? You were all the bill passed before we were elected to office. But if there is no responses or questions, that's okay. For Mr. Matsuda, Ms. Mokes, thank you very much for your attendance here this morning. And I just hope that you can appreciate what we go through as far as learning as much as we can, just as lay people like others out there like you. Okay, if there is no further discussion for agenda number 9, so there is no further discussion. At this point in time, there being no further business, the meeting is adjourned.